Junior with a next quickly. Motion. Yes. Also, I beg to mention item number 31, out of metal. 30. This metal will be taken over 2 p.m. 2 p.m. At 2 p.m. maybe taken. Offline. May Lordship, I beg to mention item 19 and item 2. In item 9, yes, Lordship, in item 19, we want to file an additional affidavit. So matter may be fixed on 4th, Lordship. Yes, item 19 and item 38 also. By today, Lordship. Mention item number 40, my lord. Item number 40, my lord. Order. This is awaited, my lord. Can it be? Anything order is A receipt. Anything order is there. My lord, my lord, another prayer, item number 4, that Kesari was called for a document for listing of an IA for orders on Monday. May please your I beg to mention item number 10. Can be as well for students who is the can be. May I please the Lordship, regarding listing the matter for watching Lordship on 2 to 7. Yes, sir. Yes, sir. Valuable. I beg to mention listing of this criminal petition, my lord, 21 matters. Informant was not received, but now they received. So it may be listed because some adverse orders. Documents I do not 37 orders. Also for the business. Products. May 3, Your Lordship. At 35 days, saying your item 13. 13, 1, 3. Motion, madam. For the day on.
Lordship, I think 36. We could take steps only yesterday, my lord. Lordship, yesterday. Lordship, P. Boulevard.
And the police is searching for the accused person?
Item number 32, Lordship. We have taken steps, Lordship, and as per official detail, Lordship. But service is awaited, Lordship. 28/1 office. And even LCR is not received. A deposit today we'll going to deposit 60 days given by the Lordship. Lord. 60 days is not completed, Lordship. 15 days is left, Lord. So, Lordship. And today case is fixed in lower court, Lordship. We are going to pay by today itself. JM Google.
Five two.
Obele.
My lord, due to personal difficulties of senior, counsel may be fixed. Item number 8. Yes, my lord. Jane Khondogar. Khandagar. My lord.
Daily list for motion. Item 1.
Lordship. Yes, nobody. Last token non-APS. Non-APS.
Sorry, Your Honor. I am the petitioner in connect this case. Little due to my sleep days, that's why I'm little late. I'm little late due to. We have filed this petition for transfer of a case which is pending before Dimapur District and Sessions Dimapur, Your Lordship. If we go through the records itself, Your Lordship, the accused persons in connection is they have been recovered or detained by the Newland Police Station in collaboration with Your Lordship, Roha Police Station, and they have.
Yes.
Yes, Lordship. On that thing, Your Lordship, I need some. For that thing, yes, Lord. It's now in evidence stage, Your Lordship. Yes, Lordship. Yes, Lordship. As per section 188 is, Your Lordship. 364, 384, Your Lordship. Extortion and your lordship kidnapping. Charge frames under section your lordship 384. Yes, lordship.
Charge frame.
Okay.
Charge framing order is not here, but charge sheet is only charge sheet. Yes. Lordship.
Yes, lordship.
Lordship.
Yes, lordship. Yes, lordship. At present, your lordship, as per my instruction is concerned, it's in the evidence stage. Yes, lordship. Yes, lord.
Yes.
Yes, lordship. In that case, your lordship, we are going to withdraw this case here. And most important thing is that, your lordship, there is no instruction from our client. We could not. Yes, yes.
No.
Yes,
Lordship.
no, your lordship. He is not fixing the trial. However, as per the instruction is concerned, your and there is no communication between us as a case counsel. We have tried so many occasions and also asked them to furnish the documents. Yes, Lord. Yes, yes, yes. Yes, yes.
One.
District and Session Judge, your lordship, Dimapur. Yes, Lord. Oh, yes, Lord. Yes. Yes, Lord. But that's a Lord, my name is SD Roy. Yes, Lord. Can it be recorded SD Roy? Much pleasure.
Item 2.
May I please your lordship, password the matter for time being.
Cases regarding absconder in search sheet. Cases regarding my absconder in the search sheet. Thereafter he has not appeared after receiving the summons. Mojibur Rahman.
My lord, password for time being. My senior is laying on.
That's seated, my lord. Thereafter, summon issued. First he has not received. Thereafter, yes. Page 17. First.
Someone.
Page 17 में kindly.
Page 70.
17 में. Page 17.
Hmm.
There,
Well,
my lord,
the absent with what is SHP? Like
SSP, my
petition.
lord. Yes,
Okay. Without any.
yes. First, my lord, he was allowed the petition, my lord. Thereafter, again, my lord, he
Which
was
one? Which one?
first 7425 petition allowed. 7425, that is page number 17.
17.
17.
Okay. Well, he appeared through
Yes,
council.
council, man. Thereafter,
Huh.
again on 15/5, he has not appeared. Thereafter, that is why NBW.
Without any.
Without
step.
any steps.
There's some. See, these steps, they have typed it as STPH or something like that.
Yes, without any
Steps.
steps.
Issued. Okay. For some time.
Lost.
Item 3.
MSRP not received. Received. Eleven one. 11. Student transfer a vehicle. Yes, what is the case about? Let us understand first.
Lordship.
Who is the petitioner?
Petitioner.
Iftikhar Ali.
Last order throws some light, my lord. Page 41.
1 minute. Let us go serially.
Lordship.
Taluk Bari. Iftikhar Ali. Where is his
Page-
name in the? Okay, Iftikhar Ali.
Page
First information report.
complainant Iftikhar Ali, son of Muhammad Jamiruddin Ahmed, lodged an affairs statement he is a registered owner of Maruti Alto vehicle. The accused which order you want to say?
My lord,
11/11/2025, passed by the Lanark Court of Kamrup, I mean,
1 minute. Okay, 1 minute. Okay,
page number 41.
1 minute.
first, your lordship may kindly come to the
Then,
third sheet first.
Charge sheet submitted.
Third sheet submitted.
Where is
And
the
there's a
charge sheet?
fairly peculiar, my lord,
Where is the charge sheet?
third sheet. Page 32, your lordship will find the operative part. No? Here it is stated that,
1 minute.
the-
Let me read, let me read.
Lost.
I have not understood.
yes, my, there's peculiar, man. Page-
So, that Runumani is the sister of the
Iftikhar,
informant and Zamiruddin is his father.
yes.
And father, by forgery, has transferred the vehicle from son to daughter. That
Daughter.
is the allegation.
That is the allegation. And they are praying for
So
the
you are
zipper.
the estranged son or what?
No, my lord.
They were for the.
You live in the same house.
Yes.
Yeah, and,
Huh?
previously they were residing in the same premises and same house. Subsequently, after marriage of the petitioner, he was thrown out from their house.
So submitting a report. Where is it? Now, where is your sister? Because she has the vehicle. Without hearing her,
He is the vehicle.
she has the vehicle. Without hearing her, how can we decide?
My lord, since the
Let me-
father of
It is clear that she has, presently the registration is in her name. Meaning thereby she has the custody and possession of the vehicle.
my lord.
Without hearing her, how can we decide this?
My lord, at
No
the time
can
of
decide.
Yes, and trial court also is exactly
Ah,
same thing.
Simple. I have clearly said
Yes,
that she is having the custody.
officially seized the now.
Officially,
My lord,
she is so without making her party, this cannot be
by the
decided.
Lanet court below, she was heard, my lord.
Huh?
By the Lanet court below, she
So
was.
Lanet court below has heard.
Yes,
So this court should not heard.
Yes,
Is it your submission?
my lord.
Okay, then that is submission recorded, then I'll dismiss this.
No, my
Should
lord.
me,
Party court.
that person who has the custody of the vehicle,
My lord.
Party.
right? You have not made him her a party.
Yes, madam, I am sorry
yes
in that
cannot be
regard,
directed.
but my humble submission before the Sadar Court, since the father of the petitioner has been solicited, he has been made the party, my lord.
No, but the vehicle is.
Oh, yes, my lord, quite right. I may be permitted
With your
to.
sister. You take your appropriate steps to implead the her.
My lord.
Otherwise, how can?
My lord,
We
I
cannot
may-
direct without hearing. The first principle of law is that one should not be condemned without hearing her.
Yes, my lord.
Right? So we cannot direct that take out this vehicle from her custody without hearing her.
My lord.
Right? You make an
So I
appropriate
may be-
application for impleadment
Yes, ma'am.
first.
I shall do it.
Okay, Mr. M.S. Ali, learned counsel for the petitioner has sought for 2 weeks' time to implead necessary party in this proceeding. So stop. Mr. M.P. Gusami, learned additional public prosecutor for the respondent number 1, state Gusami is present. So stop. Leaves the case after 2 weeks. Praise allowed. There made by Mr. Ali is allowed. Leaves the case after 2 weeks. You file impleading petition.
Obligation. Highly agree.
Item 4.
You made some prayer, somebody
Yes,
made
ma'am.
prayer or no? Where's the ID? What is the case about?
Case is lordship petitioner happened to be the Anganwadi worker
Ah,
under child development project lordship. And the impugned affair all relates to a malpractice regarding IAY houses lordship that is under log development under the panchayat and rural. So petitioner nowhere
Scan copy received.
Scan copy, no, my lord, scan copy of
Yes.
the CD was called for, my lord, not received, my lord. So I
even
paying for a date, my lord.
Why it is in the motion stage for last few years? Who is
Yours. I come
in
up
the
with-
case you were arrested?
Yes, I was arrested.
Where is your,
So thereafter.
okay, in the FIR, there is nothing, nothing specific, right?
Specific.
You were arrested.
I was arrested and pursuant to my arrest, Lordship, I was placed under suspension until
Do you have the forwarding report?
I don't have the.
No, my lord.
Why you were arrested? There might be the ground of arrest,
Yes.
It is my Lordship case that it was called.
but you could have,
Look into in a.
you could have annexed it. Huh? We don't go for fishing inquiry.
Can place it, Lordship, by way of it.
Because we don't know, because you were arrested thereafter, you were arrested on 21/8/2023,
And this.
right?
Yes, Lordship.
Then thereafter you might be released on bail.
Yes, I was released
Ah.
bail, but since.
And that is why you were suspended.
Suspension, Lordship.
There might be
That-
material
that
in
is
the
not
investigation.
Yes.
FIR may not reflect,
Main-
of it might be a big conspiracy.
Lordship.
Heard Ms. T. Shomla, counsel for the petitioner, yes, and Mr. MP Goswami, learned additional public prosecutor for the respondent state. Those. You notice returnable. So, Mr. Goswami,
Lordship,
this man is required, respond number 2.
my lord.
Not required, I think.
Perhaps not required.
Not
He is there as an informant here.
Respond number 1, state of Assam. So at this stage, there appears to be no necessity to issue notice to the respond number 2. So, as Mr. Goswami has already did not, no formal. Who is to produce? Scan copy?
Scan copy of the CD, my lord, will produce.
Okay. Mr. Goswami has sought time to produce the scanned copies of the case diary, concerned case diary. Sought for is the case on.
Second verse.
Can it be in the
But
little large?
you are quashing. You are seeking quashing without furnishing the required documents.
I'll file an
It
additional.
is up to you.
Obliged, Lord.
Item number 5.
Please, your lordship. To file.
So, and the candidate are registered.
My lord.
Huh? This is revision. Against what? Assistant Station Judge. Is the name of the Ananto Tati. Ananto Tati. 7 years. Yes, what is the ground for revision?
My lord. at first,
Eyewitness is there. Eyewitness.
Only is amongst the PWS.
Eyewitness is there or not there?
Only, my lord.
Only you will not do. Firstly, say eyewitness, yes or no.
After going through the evidence on record, amongst my lord, 8 witnesses were examined. Out of that, only 2 witnesses. On circumstantial evidence, my lord, not the directly eyewitness.
Consider evidence, it is also stated there are no
These articles also.
eyewitness to the incident. Right.
Weapon also not seized
During
by accused person.
1 minute. Keshav Karmakar. Keshav Karmakar. Conviction is under
My lord, under section
341,
341, 341,
326.
326 and 307, my
So,
lord.
The victim is the injured and eyewitness,
Yes.
is it not?
My lord.
So
PW.
there is a victim.
Yes, my lord.
He is the eyewitness.
Yes, my lord. That's all.
Then
Yes,
I have
ma'am.
asked you without looking at the document whether there is eyewitness or not.
No, my lord.
So how he is examined?
All the sentences, my lord, it is under section 341,
Accused
356,
point 4. Where is, how he is examined? PW1.
my lord.
Page,
Obes Kormakar.
page 13, page 30, era
So why
14.
court has said that there is no eyewitness?
No,
PW,
my lord.
it is there, PW 3, my love.
PW2.
Yes, 3 and 3 also. my love.
Informant of this case is
Page
his
30.
father. He knows that his brother in the incident had happened. This is duty and sought it.
This is very clear, my love.
Went to the other side of the car, bounced
called
after
and
he
he
failed
went-
to get biscuits and came back. This one called him from behind, said, Babu, he looked by immediately and handed his.
Lordship, may kindly pay us para 14.
In the shop of Mr. Replying to him, now again, it was very saved him and pushed the accusation and later I just said it for the is well apparent for this chief. This is one. Where is the medical report? And you want to say? Which one?
Para 14, page 30, my lord. He is a eyewitness, my lord. He's as per para 14, my lord.
Page
Page 30.
30.
Page 30 of the
14.
criminal revision.
Tulu Manisha. Tulu Monikul.
Yes.
Tulu Monikul was examined.
He heard Dulumoni Kul. Perhaps he is the, my lord, victim. my
He
lord.
was
He is a victim.
running with blood. Looks like a foolproof case,
Foolproof case.
right?
He saw the accused swinging down at the victim.
Corroborates, full corroboration.
Full corroboration of the victim.
My lord, IO has not seen, my lord, weapon used at the time of.
Not required.
My lord. The column
Not
Kothari
required.
and Dow. my
Column
lord.
Kothari is not recovery is not required.
Between column Kothari and.
When
Dow,
the
my lord,
accused fled from the scene with the column Kothari,
and Dow, my lord.
and
Between
he does
column
not say
Kothari-
where he has hidden it. Where is the medical?
Medical, I'm looking at it. ma'am.
Page number 37,
Doctor evidence,
36, my lord.
page number 36.
Six.
Doctor?
Dilip Chandra Deka.
Dr. Dilip Chandra Deka.
Page 37.
Hmm.
One incise wound over left side of the neck,
Hmm.
measuring. Injury was caused with a sharp weapon and edge of the inhalation. Left side of the.
Column. Only case of the appellant is revision petition.
Revision.
Concurrent finding,
One kind.
absolute
Amul commission is.
corroboration, hard, no bail.
Regist-
Bail petition is dismissed at this stage.
Lord, my humble submission, respectful submission, please, my lord, kindly allow me to condone the delay because there is sufficient ground
Delay.
to delay to condone.
Where is the delay?
Delay.
21 days, my lord, only 21.
Where is it this?
Delay
No.
file করছো, bill petition
Madam.
করছো, delay
Concern. So another quote, one,
Only one petition has been, my lord, listed.
20, only 21 page delay, my lord.
Present petition
Delay খন অহা নাই। Yes, 6 packet.
Already condoned. Hard miss.
Yes.
Regulate council.
EBE
Legal aid, no?
Cordolo Learned Legal Aid Council for the revision petitioner. And Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent state footstep. This criminal revision petition under section 442, read with section 438, Bharatiya Nagorik Surakha Sanhita 2023 is preferred against a judgment and order dated 24/7/2025 passed by the Court of Sessions, Golaghat Appellate Court for short, in criminal appeal number 25/2023. To stop. By the judgment and order it is so and so, the appellate court has dismissed the appeal and thereby, affirming a judgment and order of conviction dated 22/8/2023 of conviction and sentence passed by the Court of Learned Assistant Sessions Judge Golaghat in Sessions case number 216 of 2022 trial court. By the judgment and order dated so and so, the trial court had convicted the revision petitioner for the offenses under section 341, section 326 and section 307 of the Indian Penal Code. Stop. For the offense under section 307, IPC, the revision petitioner had been convicted, had been sentenced to undergo
341.
rigorous imprisonment for 7 years. Full stop. For the sentences passed under section 326 IPC and section 341 IPC are lesser in for rigorous imprisonment for 5 years and 20 days and simple imprisonment for 20 days respectively. The sentences are ordered to run concurrently. So stop. I have gone through the grounds urged. The revision petition is admitted for hearing. The case records of so and so and so and so be called for. Issue notice returnable on so and so. As Mr. Swami has appeared and accepted notice on behalf of the state. Respondent number 1, formal notice is necessary. Para on it next. Third is PV Bordoloi, Learned Counsel for the applicant revision petitioner, and Mr. MP Goswami, Learned Additional Public Prosecutor for the opposite party as respondent. Stuff. The instant application is preferred by the applicant revision petitioner seeking suspension of execution of the sentence passed against him and for his release on bail. Full stop. Para. The applicant as the revision petitioner has preferred the accompanying criminal revision petition number so and so. Against this again লিখি দিব para offense the injured deposing as PW injured was examined as PW 2 injured victim and his testimony as regards the assault on him by the accused, that is the applicant revision petitioner, remained unshaken. Full stop. The testimony of PW2 was lended corroboration, received corroboration from PW4 and which are not PW3. A PW3 and PW4 who also witnessed the incident of assault. Full stop. The medical evidence was in support of the testimony of the injured victim PW2. Full stop. Para in view of the above, this court does not find any, does not find whether the instant application suspension of execution past execution on unmerited application. At this stage, let
Item 6.
Your Lordship, we have preferred this transfer petition for transferring the NICR case. Same matter, Lordship.
Same.
Yesterday, Lordship disposed. So item number 7 also same.
Same. Order to asli. Order to.
What doubted?
Now 7. Why do? Same.
Or objection.
Nili quota ka divas.
Item 8. Please, Your Lordship,
Legality judgment.
against judgment and order dated 20.
Maybe let it be on the raise family court. Let the raise decide to list the case before appropriate. Order to likhi dibo. Mr.
Yes, sir.
Because this kind of petition might be listed before division. Mr. C.S. Rai, Learned Counsel for the petitioner, and Mr. M.P. Kusami, Learned Additional Public Prosecutor, for the respondent, RPEC. An order dated, not order, a judgment dated 3/10/2025, passed by the Court of Learned Principal Judge Family Court, -1, Kamrup Metro, Guwahati. In FC criminal case number 378/2023 is in challenge in this criminal revision petition under section 438, read with section 442 and section 528 Bharatiya Nagorik Koteka 2023. Tarpsat ei duta order likhi dibo. next pair. Huh? Is that case? Or
Item 9.
Hey, please. This is under NI Act.
enact.
NI.
So trial court thereafter appellate court.
Well,
Concurrent finding.
well, there are discrepancy chief of the complainant and
You
the-
need suspension of sentence.
Well,
So for that, minimum is prescribed.
20, I'll store the some special circumstance that can.
That can be, but what are the special circumstances? Have you ever heard? Regarding non-payment, concurrent finding, we are not going to disturb as of now.
I'll
This is revision.
I'll just place before your lordship the description. And the accused petitioner, my lord, he have rebutted the presumption also by way of cross-examination. My lord,
That
kindly come
is
to page
not,
25. Page 25.
under what ground it can be exempted? Deposit.
20%. If there are some.
Non-paying capacity, yes, extremely. Suppose a widow. or
My lord is aware, my lord, that judgment, my lord, of Surinder Singh, my lord.
Hmm.
Page 520, man. Five. Though it is
520, yes.
though it is true that in the
Which para?
520 first initial line, ma'am.
Okay.
Though it is true that in the amended section 148 of the NI Act, the words used is may, it is generally construed that as a rule or shall and not to direct deposit by the appellate court is an exception for which the special reasons are to be assigned.
Yes.
Special reasons, my lord, I'm pointing.
Hmm. So exception.
Yes.
How can you, whether this discrepancy after concurrent finding of fact, right? My point is that after concurrent finding of fact, the scope in revision is limited. But what are the exceptions?
Yes, I'm coming to it.
Not into the evidence. Not into appraisal of evidence, perhaps. Let us see.
There was one more case, my lord, have granted stay, my lord, after going to his judgment.
Granted, that was the lady I granted no deposit because the lady, one lady I remember,
lady,
she was suffering for penury and plus sentence 6 months, already 4 months she was in jail.
My case, my lord,
Let us see.
if I may show the special.
Let us see.
Fine.
Let us continue.
Therefore, amended section 148 of the NI Act confers upon the appellate court to pass an order pending appeal to direct the appellate accused to deposit the sum which shall not be less than 20% of the fine or the compensation either on an application filed by the original complainant or even on the application filed by the appellant accused under section 389 of the CRPC to suspend the sentence. The aforesaid is required to be construed considering the fact that as per the amended section 140 of the NI Act, a minimum 20% of the fine or compensation awarded by the trial court is directed to be deposited and that such amount is to be deposited within a period of 60 days from the. Therefore, if the amended section 148 of the NI Act is
purposively interpreted in such a manner, it would serve the objects and reasons of not only amendment in section 148 of the NI Act, but also 138 of the NI. The Negotiable Instrument Act has been amended from time to time so as to provide inter alia speedy disposal of cases relating to the offense of dishonor of checks. So as to see that due to delay tactics by the unscrupulous lawyers of the dishonored checks, due to easy filing of the appeals and obtaining stay in the proceedings, an injustice was caused to the payee of a dishonored check who has to spend considerable time and resources in the court proceeding to realize the value of the check, and having observed that such delay has compromised the sanctity of the checks transactions. Parliament has thought it to be fit to amend 148 of the Wine Act. Therefore, such a purposive interpretation would be in furtherance of the objects and reasons of the Amendment Act of the NI Act and also section 138 of the Act.
Businessman? No way.
If I may place my lord's order,
Businessman? No way.
I'm
Both
placing
are businessmen.
that has to be taken.
এই কথা যে আমার আছে জানবো কোনো হয় ফেলবা
Presumption, my lord, that has also been rebutted, my lord, but the learned trial court has record.
No, Mr. This presumption you leave at a later stage. This presumption rebuttal. Show me anything that to do that initial exercise in a revision petition, that exercise is to be done. Whether rebuttal,
This order will. This my lord has gone to the. Yes.
compilation আছে What is your case?
Yes. Will kindly come to page 25, my lord. That is the evidence of the W1. The only evidence, the complainant, my lord. I'm reading paragraph,
Whose evidence is this?
the complainant,
Yes, please tell me.
page 25, my lord, paragraph 10. That after expiry of 6 months, when I reminded the accused persons about the repayment of money on 27/6/2023, the accused person have issued a check wide SBI Dulejan branch check number so and so dated so and so an amount of 60,000 against his account number so and so requested. And then in paragraph 11, he again says, my lord, accordingly on 10/7/23, the accused person had issued another check wide Dulejan branch check number so and so dated so and so for an amount of 1,40,000. Now, if my lord comes to the cross part, page 28. I have friendly relation with the accused on 16/12/2022. The accused person took money from me and I had taken 2 signed blank checks from him as security. Those checks, my lord, were given as security and the complainant has accepted that in the cross, my lord. My son had prepared the money receipt of the aforesaid transaction. I know what is written in Exhibit 1. There are no witnesses to Exhibit 1. It is a fact that I had taken signature of the accused in a blank paper. That blank paper has been used as a money receipt. And no evidence witness to that effect, ma'am. Execution of the money.
And what is the discussion?
And my lord, Supreme Court, my lord, in a
You
case,
had elicited from him. You had elicited by cross-examination that you took 2 lakh from him. Heard Mr. P.K. Munir's learned counsel for the petition.
my lord, if
You have taken me to that.
no, my-
That is a matter of appreciation of evidence that you have admitted by way of sometimes defense counsel does what the prosecution has not done.
no, well,
Mr.
if by way of
It will
cross-examination,
go on increasing, Mr. Munir. 20,000% is the minimum
I'm
for the
would
petition.
like to this one.
What?
He said, my lord, the presumption can be rebutted, my lord, if
Presumption can always be rebutted. Mr. Munir, we are not into hearing of the revision petition, right? We are in the privacy stage.
the learned trial court has recorded that the presumption could not be rebutted because of absence of any oral or
Mr.
documentary evidence.
Tell me, what is the procedure for admitting or issuing notice in a revision petition and to carve out an exceptional case?
I'm trying to project that one.
But I have seen, you have taken me now, 2 lakh, it is an admitted position. You have elicited from that. A security check can thereafter, if payment is not made, that can definitely convert
Yes,
into
yes.
a check for presentation to collect the amount. You have elicited from him
But I'm trying to project-
PW1. Is it not? Let us again read the cross-examination, sir. What you have done? This is the only cross-examination.
Yes, ma'am.
This is the only cross-examination.
Only one
See?
PW. ma'am.
Huh. I gave money to the accused in my shop. You have elicited.
No, this is of the complainant version.
Huh?
Complainant
This is cross.
Yes.
Is it not?
Fine.
Huh? This you have elicited from PW1. At that time of handing over the money, no one was present. You had elicited. Have you understood? Have you understood the implication of it? You extracted out of him that you give money to He gave money to you, 2 lakh. Have you understood? Let me mark then.
I had given the amount of rupees 2 lakhs to the accused in cash, but the same was not mentioned in my evidence on affidavit. I do not remember the number of.
Whatever was not there, whatever was not there, you had elicited out of him. And that both the things are to be cumulatively read. Cannot be read in isolation. You filled up the gap.
But the checks were issued for security.
No issue. He did not pay in the chief. He said, despite request, he did not pay. So he presented. It
He
can
also
be,
says that the check
uh,
amount, there were
should I
amount.
decide the revision today? Then one from Assam itself, Agar Security, Dinesh something, Supreme Court. You read that. Heard the PK mode and it council with the revision petitioner, the stuff. This criminal review under section 438, section 4. Your Nagori Kopaka. And where is your pleading regarding rebuttal? Any other ground?
Only that is.
You are otherwise you are a solvent person. Against. Where is the appellate judgment? Against the judgment and order
Judgment, my lord will find 60.
23/9/2025 passed by the Court of Planet Additional Sessions Judge Dibrugarh in criminal appeal number 5 in bracket 1,025 page 60 by the judgment and order dated Spence comma the appellate court dismissed the appeal, hereby affirming a judgment and order dated 17/12/2024 passed by the Court of Learned Chief Judicial Magistrate Dibrugarh in NI case number 190/2000 by the judgment and order dated so and so of conviction and sentence, comma, the trial court has convicted the accused under section 138 of the Negotiable Act, and he had been sentenced to undergo simple imprisonment for 3 months
3 months.
and to pay a fine of rupees 250,000, comma, with default stipulation. Para. Issue notice returnable on so-and-so. The revision petition shall take steps for service case. The respondent by post in the case records of so-and-so all first of heard the learned counsel for the petitioner soon being prepared first. The learned counsel for the revision petition has submitted that the petition has been able to rebut the presumption by the presumption under section 139 NI Act by preponderance of probability, and the same is evident from the cross-examination of the complainant who was examined as PW1. So the learned trial court as well as the appellate court has already dealt on the issue of rebuttal of presumption statutorily available to the complainant 139 NI Act, full stop. And there is concurrent finding fact, the case in hand. Para. Having regard to the nature of this pitch. 20%. 60 days. And it is. Oh, our locally. Subject to deposit of 60% in a period of 60 days from today. The operation of the hearing judgment of the appellate court as well as trial court judgment shall remain suspended. So it is further ordered that the applicant, the revision petition shall be allowed to go on bail, furnishing in bond of rupees 5,000 with one surety of the like amount for satisfaction of trial court. The revision petitioner is to place a deposit immediately after expiry of 6 days with this court for continuation of the interim order. Further order on interim pay will be subject to printing a copy of the receipt evidencing deposit of the aforesaid amount before this court after expiry of
60% or
20. That is the minimum I am giving.
I'll deeply obliged.
60 question. Okay, 60, not 20.
Item 10.
May please, Lord. I am on behalf of M.A. Mandal, Your Lordship. If he's left the court, due to urgency, he's left the court.
M.A.
Lordship. But
Mondal,
I will take it.
because I think he has left the court, he has to deposit 20%. He's not.
Matter will be taken on Monday and Tuesday, Lordship.
See, Mr. Munir, M.A. Mondal has left the court because it is a fine of rupees 30 lakh. He has to deposit 20%, so 5 lakh. He has left the court. Because you are only 50,000 out of 2,50,000. He is 30 lakhs. So he has left the court. When do you want?
Lordship, Monday or Tuesday, Lord.
On the prayer of Mr.
Yeah, Lordship.
Release the case for Wednesday.
Obliged, Lordship.
So, having heard the order, perhaps that is a possibility that Mr. Mondal has left the court. Mr. Muni's order dictation, he has heard.
Obliged, Lord.
Item 11.
Yes, sir.
Yes, sir.
Crossing.
Yes, sir. Crossing, sir. The grounds are amicable settlement, change in circumstances,
What kind of case?
498A.
Who is the petitioner? Dulal Ahmed. Yes, madam.
Dulal Ahmed, Abdul Nasser, Kitabzat Nesa.
Iranjan Nesa. Who are they?
They are the accused person, the petitioner in this case.
What is the relation?
Sir, the respondent number 2 is the wife of petitioner 1.
Let me read them. Paying on service. Read. Mother in Where is the judgment? Annexer C.
Yes. Has been page 1927, sir. 19 to 27.
Page?
Page 19 to 27, sir.
Heard, Mr.
M. Rahman, sir.
Learned counsel for the petitioners and Ms. S.H. Bora, learned additional public prosecutor for the respondent number 1, State of Assam. This criminal petition under 528 PNSS required seeking quashing and setting aside of criminal proceedings arising out of PR case number 626 2020, presently pending before the Court of Learned Chief Judicial Magistrate, Nagaon. Post of para. The respondent number 2. The marriage between the respondent number 2 and petition number 1 was solemnized earlier. Post of due to discourse and differences, comma. The respondent number 2 lost 2 affairs, comma, 1 registered as Sotia Police Station case number 141/2018 under sections 457, 354, 325, 34 IPC. And the other registered as Sotia Police Station case number 136/2018 under section 498A/34 IPC. Stop. Para. A charge sheet was late in connection with Sotia Police Station case number 141/2018, and the case was registered as PR case number 135/2019, and corresponding GR case number 660/2008. So stop. If during the trial, comma, the respondent number 2 deposing as PW1 stated that she had both the parties had reconciled the matter soon after filing of the FIRs. Post of recording such testimony, comma, and the accused persons, that is the petitioners herein, were acquitted from the charges under section 448, 354, 323, 34 IPC by the Court of Learned Judicial Magistrate First Class Vishwanath in a judgment dated 39/2020. So, the petitioners and the respondent number 2 have also entered into an settlement with regard to the subject matters of the affair. Post of this, post of it is it is in such background, comma, this the prayer for quashing and setting aside of the criminal proceedings of PR case number 6/2020 has been met. Issue notice returnable after 528 August. Returnable on so and so. Bora, respondent number 1, State of Assam. Tips upon respondent number 2, Speed Post, in view of the para last one, included above, further proceedings of PR case numbers with social remain suspended till a returnable date.
9-3.
So for any of the further proceeding. Still for the proceedings, sir.
Already granted.
Okay, of lines. Item 12.
Mention. Item.
Yes, yes.
The morning I made a mention.
Oh, you made a mention?
Yes, sir.
Yeah, okay.
Their alarm is out of station.
Okay. Miss
S. Nazni.
S. Nazdin Land Council has submitted that Mr. J. Jade Alam, Land Council, who is leading her in this case, is out of station, and due to certain emergency. He has thus paid for listing of the case when?
After 2.
After 2 weeks. List of Mr. SH Pora, Land Additional Public Prosecutor for the respondent state is present. Praise aloud, list the case on.
Into
Pleasure.
item 13.
Lordship, I am appearing on behalf of Mr. M.R. Khondokar. Please another court.
Timing.
Let us pass over for the
Order?
day.
The POXO matter.
What is the case about?
POXO matter, search it has been
What
filed
matter?
and the matter has been searched. Matter has been searched.
Matter has been searched. Not fail.
And Protection of Child Marriage Act is also there.
What is this? For what?
Lordship, that
See.
is it based name.
Crossing.
Yes, crossing. Lordship.
On the affair of Mr. Magnet Council. Your name?
A. Rahman.
Yes, is passport for the jail. Yes, is present.
Item 14.
It's Lordship. In this case, Lordship, second time criminal petition, Lordship.
Second time criminal petition.
As per order page 40, Lordship.
40.
Need to Lordship some typographical mistake in the cost title.
Has been received cost title. Okay, that is a different matter.
All the order type, page 37, Lord.
Huh? What is the case about?
Honorable Court granted bail me,
Huh?
Lordship, due to Honorable Court, Honorable Mr. Justice, Tejas Sheikh sir, granted bail to me. Thereafter, some typographical mistake in the cost title, that is residential address of the petitioner. Therefore, I file IA for correction, Lord. Therefore, Honorable Court directed me another, again file a fresh criminal petition.
Huh?
Page 37, please.
Page 37.
37. Typographical mistake, address of the petitioner, I have written.
James Suleiman.
Showing absconder in the search sheet. Thereafter, he wants to face the trial.
PO and PS category instead of Patarkhandi, Lordship. Still, Patarkhandi, I have written inadvertently category.
Let it be because this is, to my view, this is completely against Niharika.
Okay.
And many other projects. Otherwise I cannot. Ignoring any criminal petition for 528, bail is granted,
Not.
which is absolutely against the law. Is it not?
Lordship.
This has been repeated a number of times by the Supreme Court.
Lordship. Otherwise,
You raise it before other good, otherwise I'm not trying the prayer of Mr. James. Is the case. Video. Next Friday. I think that has been repeated. Niharika
Niharika.
has been repeated in many judgments.
Yes.
Don't touch upon the matter of bail
Lordship,
in 480.
yes.
M15.
So,
Lordship, may kindly pass over the matter for the time being. Dal is on.
timing.
Yes, Your-
16.
This is a petition for passing of
I
their
did
petition
crossing
number
of CR.
3 of 24, Your Lordship.
CR
25.
Where is the CR case?
Check is it starts from
Submit
12, Your Lordship. Petition is at 12.
Aziz.
Starts from 12. And the notice issued by the trial court is at page 14, Your Lordship, the type copy.
Hmm?
So this
This is
CR case has been filed in a retaliation of my previous CR case instituted before the CJM Jorhat, Your Lordship. I instituted a case against her, Your Lordship.
for
Under
what?
406.
Hmm?
Under 406 CRPC, Your Lordship. That is at page.
Marriage was solemnized between petitioner and respondent. Yesterday, just after resolution the earlier marriage between present former husband. Very grave. You instituted proceeding for dissolution of marriage.
Yes, Lordship.
When?
That is at page, Your Lordship. 46, Your Lordship.
46.
Is registered as reference TS 06 of the oblique 2024, Your Lordship.
Shoot.
Title suit,
You
Your
filed shoot.
Lordship.
What
he-
happened there?
Because he left the matrimonial home, Your Lordship.
Notice has been issued.
Notice has been issued. At page 24.
When it was instituted? June. Hmm. Marriage. What is the name of the respondent?
Sabana Yasmin.
What are these documents?
Lordship, what happened?
Page 58.
During her previous marriage, Your Lordship,
No, page 58.
actually, this is a history, Your Lordship.
No, this Amrit Singh, what is this? Pandita Das.
Actually, what happened, Your Lordship, the respondent herein had an affair with another person during her previous marriage, Your Lordship, which was dissolved on 3/8/21, Your Lordship. The wife of the person with whom she had the extramarital affair, Your Lordship, approached the police, and later on, Your Lordship, there was an agreement between the parties, the respondent and the person with whom she had the extramarital affair. They came into an agreement, Your Lordship, settlement, and that is at page 56, Your Lordship, and 56. 56 is the translated copy, Your Lordship. That is the FIR lodged by the wife of the person with whom she had extramarital affair, Your Lordship. And later on, Your Lordship, there was an agreement between them, and the record of the record from the Gabhur police station were received by the petitioner to an application in RTI, Your Lordship. This shows that the affair between the respondent and the person with whom she had the affair was settled between them. And moreover, Your Lordship, I filed an application for under section 406 of CRPC, Your Lordship. That is that page starts from page 34, Your Lordship, and wherein the trial court issued search warrant against the respondent here in Your Lordship, and search was carried on, and not much of materials were found there, articles were found there, and the process is still on, Your Lordship. The case is still pending before the learned criminal court at Sibsagar, Your Lordship. That is case number, CR case number 199 of 2024. That is before the CJM Jorhat. Moreover, Your Lordship, the respondent, during the substance of her previous marriage, Your Lordship, filed an application under 406 against her previous husband, Your Lordship, or under 406 CRPC. And that was also, that starts from page 74, Your Lordship.
Heard Mr. Dr. R. Sharma, and also got a present criminal proceeding, present criminal petition under section 528 B and F is preferred in passing and setting aside of the criminal proceedings arising out of CR case number 83/2005, presently pending before the Court of Learned Judicial Magistrate, first class AMF, not a trial court, see what first of para issue notice returnable on the petitioner shall take steps for service of notice upon the respondent by speed post 2 working days from today. Para the petitioner has projected that the marriage between the petitioner and the respondent was solemnized on 5/8/2021. And the respondent left the matrimonial house on
9/8/2021.
9/8/2021 post of earlier, the marriage between the respondent and her previous husband was dissolved on 3/8/2021. And the respondent's previous husband has instituted a complaint case, TR case number 199/2020 under section 406 IPC.
Not the previous husband, Your Lordship, this present husband. Wherein the trial court
Oh,
passed the order at page 40, Your Lordship.
TR case number 10/2021. Who instituted that?
Lordship.
Amzi.
Matter is very complicated.
1 minute. Don't. Everything is so clumsy.
Because the trial court is to be apprised of the whole.
Oh, 1 minute, 1 minute. I said correctly, perhaps you have interrupted. Page 34.
Page 34.
Huh.
Oh, CR10, yes, that's right. CR10 is, but the,
Huh? 1 minute. Second line to nalage.
the 34 is by the present husband, Your Honor.
No, it is so clumsily annexed. What is this case, page 34?
Case 34 is CR case filed by me, Your Lordship, under 406 CRPC for recovery of articles taken away by my
Earlier, comma, the petitioner instituted a complaint case, comma, complaint case number 190 of 2020.
199. Your
I'm dictating, don't interrupt. Under section 406, against the respondent on the allegation that she had misappropriated the listed article there, para having regard to the projection that the criminal proceedings of PR case number so and so has been instituted a mela fidement, comma, it is ordered that further proceedings of so and so presently pending before so and so shall remain till the return. The scanned copies of so and so be called for.
Lordship, stay for the state. Obligers.
Item 17.
Yeah, please, Your Lordship. Lordship, in this matter, cognizance has been taken against persons who are not the authorized signatory of the check. NI case, Lordship, we are challenging the order and the case, CR case, which is on page number 25, Lordship.
Hmm.
26 is the operative part. Paragraph number 1, Lordship, may I read? The
25, yes. 25.
25, 26 is the operative part. Paragraph number 1. The complainant on good faith paid a sum of rupees 5 lakhs to Padmavati Seal, which
26.
26, yes, Lordship. 25,
Ah,
yes.
yes.
Paragraph number 1. The complainant on good faith paid a sum of rupees 5 lakhs to
You indicate that this is fifth line you are reading. You indicate that you are reading from fifth line. How can I know?
5th line, first paragraph.
Make that.
The complainant on good faith paid the sum of rupees 5 lakhs to Padmavati Seal, which deals with aluminium section so and so. And for financial help and loan, the accused promised to refund the same within the stipulated time. Till then, the accused person was ready to pay a sum of 26,000 as interest. Now, in this, the averment made by the respondent and the complainant in the original case is that the accused person issued the check. Now, in the same complaint, the complainant had annexed a declaration, which is on page number 33.
Yes.
In this declaration, Lordship, the father of the petitioners claims the declaration was signed on 2015. The father of the petitioner claimed that he is the proprietor of the accused firm and he borrowed the money.
This is a type copy. Where from? Is it part of the complaint?
Yes, Lordship. This was annexed in the complaint.
Okay.
And against I, Suresh Kumar Jain, son of Motilal Jain, proprietor of Padmavati Steel.
This is a case of 2015.
No, 2022. Lordship.
2022.
And the check is on page number 34, Lordship. The check has been signed by Suresh Kumar Jain, who was the father of the petitioner.
Okay.
The petitioners are they are not the proprietor of the firm. They are not the signatory of the check. They are no way related to the accused firm.
Okay.
Moreover, Lordship, on page number 36 is the demand notice.
That is. Yes.
In the demand notice, the complainant has only sent the notice to Padmavati Steel, which is the firm. Has not made any representatives, has not made any the petitioners are not involved, not named in the notice.
Suresh Jain is not a accused.
Yes. Sorry?
Suresh Jain is not an accused.
Suresh Jain, Lordship, now on page. No, Lordship, he's not. On page number 52 is the death certificate of Suresh Jain. Suresh Jain expired on 25/6/2021.
Okay, heard Mr.
N. Karanwal.
And
Karanwal.
Karanwal, Learned Counsel for the petitioners. And Ms. S.H. Vora, Learned Additional Public Prosecutor for the respondent number 2, must some. Full stop. The two petitioners have projected that they are sons of one Suresh Kumar Jain, who expired on 29/5/2021. Full stop. Para. In connection with a check bearing number 014064 dated 27/12/2021 issued for an amount of rupees 5 lakh in favor of the complainant under seal and signature of proprietor, Messrs. Padmavati, page 34, still, Suresh Kumar Jain, the respondent number 2 as the complainant has instituted a complaint, complaint case number 2575 C 2022, which is presently pending before the Court of Learned Judicial Magistrate First Class Kamrup Metro Guwahati Trial Court. Full stop. In the complaint, the complainant as respondent number 1 has arrayed the accused as page 25, Messrs. Padmavati Steel, represented by within bracket 1, Arihan Jain, within bracket the petition number 1, and 2, Mr. Sahil Jain, the petition number 1 and petition number 2, 25. First off, to notice seeking passing of the proceedings of this number shows the present petition under section 528 BNSS is prepared issue notice returnable on so and so. The petitioner shall take steps for service of notice upon the as Ms. Mia Bora has appeared. Respondent number 2, petitioners shall take steps for service of notice upon the respondent number 1 by speed post within 3 working days from today. Para, it is the contention of the petitioners that late Suresh, the petitioner's father, late Suresh Jain, who was the proprietor of Messrs. Padmavati Steel, and the check in question or under reference was also issued under his seal and signature as the proprietor of Messrs. Padmavati Steel. Full stop. After the date, no demand notice was also issued to the petitioners after the check stood dishonored upon presentation. Para, having regard to the project, I order that further proceedings of sentence presently pending before the court of so-and-so shall remain suspended till the return. Scan copies of so-and-so.
Lordship, this is small.
11-3.
This is a small mistake in the cause title, Lordship. The name of the father of the petitioners, I have noted it down as Sunil Kumar Jain, Suresh Kumar Jain. So I may be allowed to amend that. Only that.
My correction.
Obliged, Lordship.
Time being matter, item number 2.
Motion হয়ে গেল।
May I please? This case, my lord, NBWA.
What is your explanation since 15/5/2025? What is your
And
explanation?
Still in NBWA state.
Huh?
Subsequently, NBWA is issued.
After issuance
What is
of
your
summons,
explanation?
Lordship.
Huh?
After issuance of summons.
Huh?
Yes, on
No, what
civil
is your
reduction.
explanation?
Yes.
After 15/5/2025.
After 15/5/2025, my lord, still because NBWA.
You are
is-
saying that you are law-abiding citizen. You appeared through your advocate on 7/4/2025, right? Page 17. Then on the next date, you did not appear, did not take any steps. 15/5/2025, right? NBW was issued. Thereafter might have been reissued.
My lord, on
Reissued. So what is your explanation?
my lord, on 25/6/2025, 123/6/2025, I have approached before this court.
Where?
123/6/20.
Huh?
It is filed, my this criminal proceeding filed.
Adjourn for the day. Then you have not showed any.
No, my lord, this matter is not listed, my
No,
lord.
no,
I
you
was-
have not shown any Passover adjourn for the day.
But
Yes.
then there, my lord, that I was,
Huh?
I,
You seem to have no urgency.
my lord, I was waiting for listing, my lord.
Oh,
Only not listed.
Mr. H.R. Chaudhary,
My lord, I have made a
who makes
mention,
mention
I have made a mention
almost regularly
in the meantime,
before the court
my lord,
for non-listing of the case.
my lord, in the meantime, I have made a mention before the court number 8. Court number 8 permitted for listing. However, matter was not again not
So
listed.
for about 6 months, you are not
Then
making mention.
one time, my lord, I have approached before the registry also. Now it is listed, my lord. I have made a mention 2 times, 2 occasions. I don't know why this matter was not. Now this matter is listed today, man.
Yes.
His lordship, search sheet was filed on in the year 2020, lordship. Thereafter, someone has been issued by the order dated 22/07/2024.
Let him appear. He is the only accused. But we keep it amends.
Till the next,
Let the call be taken by the trial court.
yes. Trial
Well,
court will
I am
decide in
Or the
accordance.
period, we cannot set aside because it is correctly, it is a correct order.
Lordship.
We cannot set it aside.
I have permission, my lord.
Only we can keep it in
Abeyance
abeyance,
till the next day's.
allowing him to appear before the court.
And the trial court will decide in accordance with.
Otherwise, this is perfectly okay order.
No.
I have most submission. It is, since the matter is a not available, my lord. If I will appear, my lord, I have appreciation that I may.
That I can't help it. That is the law. I cannot change the law. I can keep the NBWA in abeyance only for period of 15 days saying, to allow you to appear and make an application before the,
Yes.
that's all. I have no other option.
Then your lordship may allow me to adjourn this matter.
No. After first you made a prayer for timing. Now it has come again. This time I am not permitting it. Just because the court has expressed
Well,
adversely.
By this time,
There's no prayer.
I may show some.
No, that cannot be. I can only allow you 15 days time to appear before the court because you have taken the court for a ride. First you took the steps with your lawyer Then on the second date, you did not appear. Then you did not show any urgency also. You kept it pending. Is it not?
I made a mention,
We don't know. There is no record.
made a mention before the court number 8.
Only mention memo is there, Mr. Chaudhary. Whatever mention memo, it is always available in the case.
But it,
You made a mention before court number 8 on 22nd January 2026. That is allowed. I can give you 15 days time.
for the sake of trial, my lord, if there is an apprehension, my lord, if I appear before.
This is a case of dowry debt, mister. You have to face the consequence. Heard Mr. HR Sotil and counsel for the HR Sotil and counsel for the P. Mr. Chaudhary, read paragraph 5. Read. He could not receive summon. On non-receiver of summon, the learned additional chief judicial magistrate issued NBWA against the accused petitioner by passing order dated 15/5/2025. Now let us come to page 17. Page 17 or the main original order, page 18, 7/4/2025. Read. TM is transferred. Is it not a false statement?
Not at
It entails cost. Also cost. Is it not a false statement before the court by the petitioner? Is it correct or not? Correct. 5,000 cost. Hard, Mr. HR. No, absolutely. We don't allow all this. We don't allow all this false presentation, projection before the court. Absolutely not.
In fact, my lord, I was stated that way that someone.
You are the counsel along with Z. Talukdar who has drafted this petition. Is it not? So making a false statement is what? Action should be initiated before the Bar Council. Making a false statement. Absolutely contrary to what has been recorded by the trial court. Yes, Ms. Bora.
It should not be allowed. This kind of
petition should not be allowed. Should not be allowed. I am simply dismissing a petition imposing a cost.
Cost part may be deducted by. This cost part may.
And also dismissing nothing on merit. You took me to that para this criminal petition under 528. BNSS is preferred to a sale and order dated 15/5/2025 passed by the Court of Learned Additional Chief Judicial Magistrate, Sribhumi Trial Court. By the order dated 15/5/2025, the trial court has directed issuance of warrant of arrest within bracket NBWA to the accused comma, who is the petitioner hearing? Stop. Para. The vaccine brief is that on 20/03/2017, comma, an FIR, a first information report was lodged against the petitioner and 3 others by the informant, who is the brother of one Romana Begum. So, Romana Begum was married to the petitioner. Full stop. In the FIR, comma, the informant had inter alia alleged that after the marriage of Romana Begum with the petitioner, comma, 2 children were born to them. And during the it was further alleged that subsequent to the marriage, comma, Romana Begum was treated with cruelty. Full stop. It was further alleged that on 19/3/2017, comma, Romana Begum was killed in her matrimonial house in a pre-planned manner. Where on receipt of the charge sheet, comma, on receipt of the FIR, comma, the case, comma, Koreanganj Police Station case number 260/2017 was registered under section 307, 302, comma, Indian Penal Code. Full stop. After completing investigation into the case, comma, IO submitted a charge sheet on 172 CRPC of right, charge sheet number 511/2020 on 39/2008, finding a prima facie case established against the petitioner for committing the offense under section 304B/494, IPC. In the FIR, comma, in the charge sheet, comma, the IO mentioned that during the period of investigation, comma, the petitioner was found absconding. Full stop. Around submission of the charge sheet in connection with so-and-so police station case number so-and-so, comma, corresponding GR case number 603/2017 and PR case number 1559/2024, comma, the court of Laret, the trial court took cognizance of the offense under section 304B/494, IPC against the petitioner, he being the charge sheeted accused person, on 22/7/2024. So after taking cognizance, comma, the court on 22/7/2024 issued summons to the petitioner for his appearance on 23/10/2025. So stop. Para. From the orders is annexed to this criminal petition, comma, it transpires that till Seven 4/2025, comma, summons issued to the petitioner was not returned after service. Till 30/01/2025. 25. Full stop. On 7/4/2025, comma, the petition was filed on behalf of the petitioner is that it engaged counsel a petition, petition number 3148, seeking exemption from personal appearance on that day, and the learned trial court allowed a seat prayer, fixing the next date on 15/5/2005 for appearance of petition. Para on 15/5/2025, the petition was found absent before the trial court without taking any steps. Stop. It was in such situation, the trial court had ordered for issuance of warrant of arrest with bracket NBWA against the petitioner. The order dated 15/5/2025 passed by the trial court is found to be in conformity with the provisions of Section 90 within bracket small b, B and SS, and therefore the order does not call for any interference. Full stop. Para. In this criminal petition, the petitioner has averred that in paragraph 5 has averred that he did not receive the summons, and on non-receipt of summons, the trial court issued non-bailable warrant of arrest against the petitioner by passing an order on 15/5/2020. Para. The above statement made in paragraph 5 of the criminal petition is clearly a false statement. And the same is contrary to the facts revealed from the order sheets, including the order dated 7/4/2025 and 15/5/2025. Stop. Para. In the above view of the matter, this criminal petition is dismissed, imposing a cost of ₹5,000, which is to be deposited before the registry within a period of 2 weeks from today.
Both part may be detected. Actually, in fact, my lord, it was stated that someone was not received, so NBW, or he appeared, my lord. That's our NBW issue. At least, my lord, that part, my lord, earlier, my lord, never happened earlier.
Be careful.
My lord, at least
5,000. It is not for you also, for others also.
Yes.
On deposit of the aforesaid amount, before the registry, the same is to be remitted in favor of the Guwahati High Court person.
This is an application for causing of a complaint filed by the respondents as a petitioner. See what happened, he closed 2 FIRs. First FIR, police investigated and submitted final report. Thereafter, in 2012, he again filed a FIR. His allegation is that police has not taken action, so he filed a complaint.
Let us see.
What's my please to see paragraph 6.
1 minute.
Page 5.
Who is the petitioner? Basant Kumar Agarwal.
What's if there is a business transaction with petitioner and respondent?
Okay, let us.
Paragraph, let's say, come to paragraph 6.
Paragraph 6.
What's page 5. The petitioner begged to state that the respondent had closed another FIR for the same cause of action which was registered in Paltajar police station. The petitioner was called upon by the police and his statement
From
was
the
quoted.
police station.
Subsequently, police investigated the matter and submitted final report.
Where is that?
Lordship, final report did not find, Lordship, may come to page 28. And a trial court, many occasion requested the.
No, you have the FIR of that one.
Lordship, first FIR is not with me.
Huh?
Second FIR is there.
Who is the second FIR?
Lordship, Lordship, may come to page 28. Probably this order will clarify everything.
28.
Order dated 4.
What is page 24?
Page 24. Lordship is the second FIR.
Second FIR.
Lordship comes
This is
to
in
page
2012.
Lordship,
Huh.
page 28. Complaint is absent. Learned counsel for the complaint is present. But the learned counsel for the complainant peruse the case record. It appears that the case record that one FIR was submitted in connection with the case by Paltan Bazar PS bearing number so and so on 26/5/2013.
That is a subsequent thing, I think.
Lordship, what happened there? The allegation is that.
That was second FIR, perhaps.
Lordship, there are two FIR.
No, see page 24.
Yes, Lordship.
That this FIR has been registered on 25/12/2012.
Yes, Lordship.
And the mention in page 28 is of
the order dated 28.
3/24/2013.
Lordship,
So
this-
that is the second FIR.
There is, that is some confusion is there. So,
But apparently,
yes, Lord. Correct.
apparently
Yes, Lord.
mention in page 24
Yes,
is
Lord.
of the second FIR.
Yes, Lord. Correct.
Huh.
But the same FIR could not be found by FR branch, and FR branch was directed to find out the case record. But till date,
Hmm.
though the 6 dates has been given by the court, the same FIR is not received from the FR branch. Hence, dealing assistant of FR branch is directed to find out the said FR and as early as possible and submit before.
Let us read the FIR first.
Lordship, allegation is that, Lordship, yes, page.
Let me read the
Page 26.
Let me read the FIR.
Yes, Lords. Married Lords. Page 26.
Let me read.
Lords.
Okay. It was registered.
No, Lordship, FIR was registered. Police didn't take any step. This is allegation of the petitioner, Lordship. Then he filed complaint before the.
This FIR was not registered.
No, FIR was registered.
FIR was registered.
Allegation of the respondent is that police has.
What is the case number?
Lordship, case number is Paltan Bazar Police case number 1196/2012.
Where from we can get it?
Lordship, page
Okay.
24. Top.
What is that number?
Lordship, 1196/2012.
Okay, 1196/2012. Okay.
Lordship, thereafter he filed, after more than 10 years, he filed a complaint before the mandate magistrate. Lordship, please to see his prayer. We have annexed the complaint. That is page 32. So his prayer is at page 38.
Okay.
Married law. Page 38. The premises most respectfully prayed that your honor may be kindly admit this petition instant complaint petition filed under
Agreement.
section 156 3 of CRPC
Annulment
may issue direction to the concerned
agreement.
investigating official in the incident case to promptly complete the investigation and status report along with the documents dealt with the accused based on the materials provided by the appellant the time of lodging the FIR number so and so. Then 2, issue direction to the investigating officer in the incident case to submit periodic report during investigation. So this was a prayer. Then let's say in 2025,
Pronounced.
the learned magistrate,
Sakari Bosu.
Lordship may come to page 41.
Page?
41. The order dated 4/11/25.
It is.
The complainant is absent, showing cause, right petition number so and so, hence, seen, heard, petition is allowed. Heard the learned counsel for the complainant and peruse the statement recorded during inquiry and also case record. From the statement of the witnesses, it is seen that the prima facie case against Basant Agarwal under section 420 IPC, as sufficient materials are found against the accused Basant Kumar Agarwal under section 406 IPC, issue summons against him. Complainant is to take step.
So there has to be pre-cognizance here.
Yes, Lordship. My submission, Lordship, notice is to be issued to me.
Art. Mr. S.C. Kyle, Learned Counsel for the plea. The instant criminal under 528 E and deferred. Seeking quashing of criminal process arising out of CR case number 2231/2000. He preferred an application under 156(3)
He, Lordship.
and
Lordship,
the court has
taken cognizance under section 420 against me without issuing any note.
okay. 2231/2021. Presently pending before the Court of Learned
Additional CGM to go.
Additional Chief Judicial Magistrate Kamrup Metro Guwahati Trial Court and an order dated 4/11/2025 passed by the trial court connection with complaint case number 231/2001. So by the order dated 4/11/2025, the trial court finding a prima facie case against the petitioner for the offense under section 420 IPC, issued summons for the petitioner's appearance on 17/12/2026.
Yes, Lordship. No, Lordship, it is,
11 months later.
no, Lordship.
Huh?
It is wrongly, it is 20, it should be 25.
25.
25.
Taking his appearance. Kitna lagega?
Next date is fixed on
Para.
court rule.
Issue notice returnable. The petition. Will take steps for service of notice upon the respondent. In she opening response today. Para. The petitioner has averred that the complaint case, CR case number 2231/2021 was registered by the trial court on the basis of an application submitted by the respondent under section 156(3) within brackets CRPC. Stop. In the state petition, petition number 4822/2022, the respondent had alleged that there was improper investigation in connection with an FIR lodged earlier by him and registered as Paltan Bazar Police Station case number 1196/2012 under sections 420, 406, 506 on 25/12/2012. Closed down. It is further contended on behalf of the petitioner that in connection with the same cause of action, the respondent had also filed an FIR which was registered as Paltan Bazar Police Station case number 324/2013 on 26/5/2013. And after investigation, a final report was submitted, and the said fact is reflected from an order dated 4/2/2023, passed by the Court of Law and Additional Chief Judicial Magistrate, Kamrup Metro, Guwahati, in CR case number 2231/2021. So stop. It is the further contention of the petitioner that after the operation, after the provisions of BNSS decree 2023 have come into force on an with effect from 1/7/2024, the accused has a right of hearing prior to taking cognizance by the trial court as per the proviso to subsection 1 of section 223 of the BNSS. So stop. In the case in hand, such procedure was not followed by the trial court while passing the impugned order dated 4/11/2025. Post of having regard to the prosecution, therefore, it is ordered in entering that further proceedings of so-and-so presently pending before the court of so-and-so shall remain suspended till the returnable date. তার আগতে লিখক scan copies of so-and-so be called for.
Proceed. Item 44. Item 44 of supply list. Both party amicably settled this case. We want to withdraw this, close the case.
Okay, wait for your turn. Wait for your turn. Not the will. Yes.
Otherwise, you want to withdraw.
Who wants to withdraw?
We do discuss.
Okay, wait for your turn, sir. Be patient. You should have mentioned it at 10:30 itself.
Yes, sir. For upgradation item.
Huh?
In the morning, you have mentioned upgradation item number.
Which one?
Item number 31.
Oh, we don't do upgradation. I thought that it would meet, will take up some time. Yes.
Well, the case, well, we have challenged the cognizance of the proceeding, well.
Cognizance order.
Because, well, there is no enforceable debt. What happens, my lord?
NI case.
NI case.
Okay. Who is the complaint?
Complaint, my lord,
Who is the complaint? Complaint.
Yes.
Complaint.
That page, page 37, my lord.
37. Bahadur Ishwar. Who are the petitioners? Yes. Just see 37.
Yes, ma'am. The six in question, my lord, we have filed an additional affidavit, my lord. It's an additional affidavit.
It's in question.
Inadvertently, we could not annex it, complaint, petition itself, my lord.
How many checks?
My lord, 3-6.
3 lakh, 2 lakh, 2 lakh.
Yes, my lord. Oh, yes, my lord.
Let's see the complaint first.
Yes, ma'am.
Complaint is a farmer. Where is the agreement? Agreement?
That agreement, my lord, we have not annexed here. Because, my lord, the complainant himself has admitted in his complaint petition that there's some certain, my lord, pages of the agreement was missing, my lord. Kindly see, my lord.
Okay, let me read the.
Yes, page 40. Page
Let
40.
me read the complaint first.
Yes, ma'am.
Yes, after complaint, cognizance taken.
Yes, cognizance taken, my lord.
Where is the cognizance order?
Page 32, my lord.
And what is the stage?
So it's fixed on 10th of February for appearance. We've been appearing.
So far as if we look at the check,
Yes.
and so far as petition number 1 is concerned,
Yes.
two, that is there is tribal issue.
Tribal issue.
But so far as petition number 1 is concerned,
Not a signatory.
not a signatory, to that extent, yes, you have made out a key.
And yes, my lord. One is covered by the Supreme Court decision also. One
But
is
second one is not at a stage of
may submit, my lord. So what happens, my lord, the complainant and the respondent number 2, petition number 2, my lord.
that is to be rebutted.
That's correct. That's also.
Presumption is there, we cannot
No,
go
no, that's a minute, my lord. So what happened, they had the agreement, my lord. She participated in the tender process of the oil, my lord, for procuring one vehicle, my lord.
That document cannot be looked into in a quashing
My lord,
petition.
just for a moment, my lord, page 20, my lord, page 20, my lord. Because along with the, my lord has already inquired about this agreement, my lord. Along with the agreement, there is a general power of attorney given to the complainant. Kindly see clause 10, my lord. To deposit the money, page 21, my lord, page 21. Page 21. This is a power of attorney. He has admitted in his complaint petition itself, my lord. To deposit the money, only 15% as down payment for purchasing the said vehicle in
Those
my
cannot
name.
be looked into, sir,
Well,
Mr. Chakraborty.
Yes, my lord, that's correct.
This document cannot be looked into, so that clause cannot be looked into.
Why,
This
my
is
lord?
not an
No.
unimpeachable document.
That's correct, my lord.
So we are not going into that. When the document itself cannot be looked into,
What I'm trying to say is
you
that,
see
my
the parameters of
Yes.
482 or
Yes.
528.
Correct.
You cannot go into that, then not to speak of some clauses in the agreement.
All right, my lord. My lord,
We are not going into look into that document.
my lord, then my lord, one more document, if my lord pleases, my lord, page 26. There is a self-declaration given by the complainant, page 26, my lord.
That also is to be looked in.
And
By the trial court.
having known these things, my lord, immediately we have
You know
lodged
the
an FIR.
parameters
Yes, my lord. We have lodged an
of
FIR.
482.
Yes, my lord.
Unimpeached. These are not unimpeachable
Correct.
documents of unimpeachable character, which are to be looked into by the trial court.
Correct, my lord.
And you have every opportunity that this is not a legally enforceable debt on the strength of this power of attorney and agreement.
Correct, my lord.
That is your defense. Right. So what is the judgment?
Yes,
Signatory.
So far as the signature, this one judgment, my lord, there are two judgments in fact. This 2013 judgment, my lord, Mrs. Aparna
Upward.
A. Shah. Straightway, my lord, para 22, my lord. May I read, my lord? Para 22, it says, in the light of the above discussion, we hold that under section 138 of the Act, it is only the drawer of the check who can be prosecuted. In case on hand, admittedly, the appellant is not a drawer of the check and she has not signed the same. A copy of the check was brought to our notice, though it contains name of the appellant and her husband. The fact remains that her husband alone put his signature. In addition to the same, a bare reading of the complaint as also the affidavit of the examination chief of the complainant and a bare look at the check would show that the appellant has not signed the check. Next parameter, we also hold that under section 138 of the NI Act, in case of issuance of check from joint accounts, a joint account holder.
It is not a joint account.
This is not even a joint account.
Not a joint account. And there is no conspiracy or 120B.
Yes, my lord. Yes,
120B,
exactly.
420.
Yes. That's what, my lord, even if in a joint account, my lord, if the other account holder doesn't sign, my lord, then he or she cannot be prosecuted.
You would have got He could have got a better case, better judgment.
The same second judgment, my lord, I have also given. That is
Yes, please.
Alka Kandu,
Ah.
para 7, my lord. The same line, my lord. Down below, my lord, even, last but one para, even in case of a joint liability, in case of individual persons, a person other than a person who has drawn the check on an account maintained by him cannot be prosecuted for the offense under section 138 of the NI Act. A person might have been jointly liable to pay the debt, but if such a person who might have been liable to pay the debt jointly cannot be prosecuted unless the bank account is jointly maintained and that he was a signatory to the check. The law is already settled, ma'am, regarding this point.
Yes, Ms. Bora, anything to say? This.
My lord, I would like to place one more judgment, lord, if my lord pleases, regarding the, my lord, the maintainability of the.
Maintainability of what process?
When we have, my lord, contradicted the evidentiary burden, my lord.
What is evidence?
Look,
Evidence is not yet laid.
that's correct, my lord, but
You go by Rajiv Thapar or Rukmini Narlikar, not by this one. You have not laid any evidence. This is that presumption is
Yes, ma'am,
rebuttable
prima facie.
presumption 139, 118. So this has to be rebutted. Rebuttal cannot be made in a petition. Yes, extremely unimpeachable character, right? That is, these two are not unimpeachable character. These two documents. These are to be exhibited, proved.
That's good.
By preponderance of probability, you have to
Yes.
discharge that pardon. You have a pardon of lighter character than the accused.
So for petition number 1, Lord, he has to.
This criminal petition under 482. Section 480, trade with section 07, of criminal is preferred by the two petitioners seeking quashing and setting aside of the criminal proceedings of a complaint case, NI case number 19/2023, is presently pending for the Court of Planet Sub-Divisional Judicial Magistrate, within bracket S, Dibrugarh, trial court. So, the respondent number 1, the facts, the background facts can be stated, briefly, as follows, the respondent number 1 herein, as the complainant has instituted the complaint case Where is the complaint?
Page 37, my lord.
Before the court of the next Chief Judicial Magistrate, Dibrugarh, in the year 2000, 23. What is the order taking cognizance?
Is 32, my lord.
In December 2023, arraying the two petitioners herein as accused number 2 and accused number 1 respectively. Full stop. The complaint has been filed against the two accused persons alleging commission of an offense enactment under section 138 of the Negotiable Instrument Act 1881. Full stop. After registering the complaint, the complaint case, NI case number 219/2023 was made over to the Court of Planet Shivji as Dibrugarh Trial Court for disposal. Stop. Para. Upon receipt of the complaint and an affidavit in the and the initial deposition of the complainant under section 200 TRP in the form of an affidavit, the trial court finding sufficient ground for proceeding under section 138 NI Act against the two accused persons, that is the petitioners herein, issue to cognizance of the complaint and issued process to the petitioners for their appearance to answer the allegation made by the complainant. Post para. I have heard Mr. R. Chakraborty, learned counsel, for the petition. Post and Ms. S.H. Bora, learned additional public prosecutor, but the respondent number 2, State of Assam. Stop. Despite service of notice upon the respondent number 1 as complainant, the respondent number 1 has not appeared before this court. Post para. It is the contention of the learned counsel for the petitioner that insofar as the petition number 1 is concerned, he was not a signatory to the checks involved in the proceedings of CRCS number so and so. Full stop. It is further contended that there is no legally enforceable date in respect of the petition number 2. Petition number 1. And the said fact would be evident from from a general power of attorney executed by the petitioner number 1 in favor of the complainant, respondent number 2 complainant on 20/12/2021 and a declaration. Page
26, ma'am.
executed a receipt of ATM card declaration executed by the respondent number 2 complainant in presence of witnesses, including the petitioner number 1. Full stop. It is by referring to the declaration, it is contended that a checkbook of Punjab National Bank Duliajan branch containing 20 number of check leaves ranging from 132,781 to 132,800 was handed over to the respondent number -2 complainant, and the key checks under reference were among the check leaves handed over to the respondent number 2 complainant by the petition number 1 to carry out transactions on her behalf with Messrs. Indian or Oil India?
All India.
Oil India Limited. So, para. In the complaint, the respondent number 2, this complainant has averred that there was a business relationship between the complainant and the petitioner number 1.
2, Malal.
2. With regard to supply of vehicle to Oil India Limited, Duliajan, and the same and the talk of business fructified into a business agreement. Full stop. The complaint has alleged that he was made to invest a sum of rupees 7,29,791 on the basis of the agreement executed between him and the petitioner number 2. And on the strength of a power of attorney, full stop. The investment was made on behalf of the petitioner number 2. Stop. When But the petition number 2, in bracket, accused number 1, in collision with the petition number 1, in bracket, accused number 2, violated the conditions, terms and conditions of the agreement and the power of attorney. And withdrew an amount of rupees 12 lakh, about 12 lakh, from Messrs Oil India Limited, and thereafter misappropriated the same without making payment of, without making any payment to the complainant. So, when the complainant made demand for his invested amount, comma, the petitioner number 2, accused number 1, had sent the following 3 checks with the petition number 1, accused number 2, page 42. Table এখন আছে। Check number 2 লিখিলে হ'ব। Para. The aforementioned 3 checks are part of the case record. Full stop. The 3 checks were issued from a bank account maintained at Duliajan branch of Punjab National Bank. Full stop. Para. The complainant has alleged that when the 3 checks were presented for collection, which is at his bank, comma, the checks were returned unpaid on the ground of insufficiency of fund in the account of the drawer. Full stop. It was thereafter, comma, the complainant, after following the statutory formalities prescribed in the NAC 1881 as amended, the complaint, he had to institute the complaint. Full stop. In the complaint, comma, the complainant made a prayer to the made a prayer for taking cognizance on the complaint for the offenses under section 418/420, Indian Penal Code, and section 138, of the Negotiable Instrument Act 1881 as amended. Full stop. Para. By the when the said complaint was registered as NI case number 219/2023. Full stop. The trial court on the after perusal of the contents of the complaint and on the basis of the initial deposition of the complainant in the form of affidavit and the documents annexed thereto, including the 3 checks, comma, to cognizance on the or to cognizance only of the offense under section 138 NI Act ended on 8/1/2024 and issued process against both the petitioners who have been arraigned as accused number 2 and accused number 1 respectively. So, para. It is from the statements and amendments made in the complaint itself, comma, it has emerged that the complainant had apparently entered into business transactions only with the petitioner number 2. Full stop. The complaint had alleged about disputes between him and the petition number 2. Full stop. The complaint has alleged that the petition number 2 had conspired with the petition number 1, comma, who is her father, comma, to cheat him. Full stop. Para. The T6, aforementioned T6, which are part of the case record, comma, were only issued by the petition number 2 as a drawer of the check from an account number so and so page 54 running maintained by her at the Duliajan branch of Punjab National Bank. Full stop. Meaning thereby, comma, the petitioner number 2 was the sole signatory of the alleged dishonored checks. Full stop. The 3 checks were issued by the petition number 2 in her individual capacity. And not either as a partner or director or managing director, etc., to bring in the provisions of section 140, 42. One, Negotiable Instrument Act into operation. Full stop. Para. Section 138 of the Negotiable Instrument Act has provided as provided as under 138 explanation. Section 138 and 130. Para. As the trial court has as the trial court has taken cognizance of the only of the offense under section 138 Negotiable Instrument Act, comma, such cognizance can only be taken against the drawer of the check. And none other. In the absence of any averments, in the absence of the requisite pleadings as regards the provisions of section 141 NI Act, more so when the check was issued, there was only a single signatory and the check and it was issued in individual capacity. Full stop. Para. In the above obtaining fact situation, comma, which judgment you want to show?
The second judgment.
From the provisions of section 138 NI Act, it is evident that before a person can be prosecuted, the following conditions are required to be fulfilled. 1, 2, therefore, comma, a person who is the signatory to the check and the check is drawn by that person on an account maintained by him, and the check has been issued for the discharge, comma, in whole or in part of any debt or liability, and the check has been returned by the bank unpaid, such person said to have committed the offense. Full stop. Section 138 of the NI Act does not speak about the any joint liability. In the absence of the requisite conditions prescribed in section 141 of the NI Act. Therefore, in the above facts and circumstances, comma, the criminal proceeding initiated and continued against the petition number 1 would amount to an abuse of the process of law. Para. Section 139 of the NI Act has provided for presumption in favor of the holder of the check and against the drawer of a check. Full stop. As per section 139, it shall be presumed, unless the contrary is proved, that the holder of a check received the check of the nature referred to in section 138 for the discharge, or in whole or in part, of any debt or other liability. Full stop. A document in a criminal petition referred under section 142, 482 CRPC, it is ordinarily, an accused person seeking quashing of a criminal proceeding is not allowed to introduce any document in support of his contention, in support of his case. Full stop. The parameters of the scope and ambit, the parameters of accessing the power under 482 CRPC, the parameters of exercising the inherent powers available to this court under 482 CRPC have been well delineated in the decision in Bhajalal versus so-and-so. Full stop. Only in the event the document sought to be introduced by the accused is found to be one of unimpeachable character, then only the same can be looked into. Full stop. The documents which the petitioner herein, the documents, that is, the agreement dated so-and-so, and the declaration dated so-and-so, which the petitioners have sought to introduce in this, have brought on record to further his case in this criminal petition, are not ones which fall in the category of documents of unimpeachable character. Full stop. It is true. Full stop. The presumption under section 139 CRPC is a presumption of law, and the same is rebuttable. Full stop. It is open for the, in such way of the full stop. It is in such view of the matter, this court finds that the proceedings, criminal proceedings of complaint case number so-and-so against the petitioner number 2 is concerned, cannot be interfered with at this stage. Full stop. Therefore, the case of the petition number 2 is the case of the petition number 2. Again, so as it is open, the presumption under section 139 an act being a rebuttable presumption, and the same the presumption can be rebutted on the standard of preponderance of probabilities. It is open for the petition number 2 to take such such defense as available in the proceedings of NI case number post of era of the discussion of and for the reasons signed therein, the criminal petition is partly allowed to the extent it is above. So for the purpose of clarity, it is clarity, it is made clear that the criminal proceeding, so far as the petition number 1 is criminal proceeding of complaint case number so and so. In case of the petition number 1 is concerned, stands first set aside. So insofar as the petition number 2 is concerned, the prayer for quashing and setting aside of the criminal proceedings of so and so is declined.
Well, one line maybe, Miller. The learned trial court will dispose of it as expeditiously as possible.
That is always inherent. That this kind of direction should not be made. That has been repeated by the Supreme Court.
Yes.
So I don't repeat that.
Deeply obliged.
Not today, we'll not get today, Monday we'll get the order because paucity of time. Yes. This is appeal.
Yes, well, criminal appeal, it has. been
Admitted or what?
Yes, criminal
Not
appeal.
area admitted.
Appeal not admitted, but
Okay.
there is an order in the IA, my lord.
What?
Naya bail has been granted.
Huh?
Yes.
By me?
No, my lord.
Heard Mr. M.U. Mahmood Learned Counsel for the accused appellant. And Mr. M.P. Goswami Learned Additional Public Prosecutor for the respondent number 1, State of Assam. This appeal, a criminal appeal under 415. PNSS is preferred against a judgment and order dated 10/12/2024, passed by the Court of Learned Additional Sessions Judge FTC Shunitpur Tejpur Trial Court in Sessions case number 165/2019 by the judgment and order dated so and so. The accused appellant has been convicted for the offense under section 304 part 2, Indian Penal Code, and he has been he or she and he has been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 30,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. So I have gone through the grounds urged in the memo of appeal. The criminal appeal is admitted for hearing. The case records of so and so will call for issue notice returnable in 4 weeks. As Mr. Goswami, respondent number 1, steps upon respondent number 2 by speed post with PD. Cart before the horse.
Lords.
Lordship, the matter may be passed over for the time being.
Matter note was issued on 28/1, and the respondent has appeared as it appears from the cause list.
Sir, you are appearing.
Lordship,
Timing.
for the timing.
Jail.
23, 24.
Suggest this
23,
appeal,
24,
this
25,
criminal
madam.
appeal from jail
Yes.
is
jail appeal.
directed against, is preferred, is against, not preferred, is against a judgment dated 19/11/2024 by Hindi Kibo, passed by the Cecil Judge Rongia Kamrup special POCSO case number 4/2018 arising out of Sanmari Police Station case number 65/2018. So stop. By the judgment and order dated so and so, the accused appellant has been convicted for the offense. Trial court, the special court has convicted. Section 4 POCSO, RI 10 years, fine 2,000, default, aside for another month. The criminal appeal is admitted for hearing. Yes, records of so and so be called for. Issue notice returnable in 4 weeks. As Mr. Usami, respondent number 1, State of Assam. The steps upon the respondent number 2 informant are to be taken in terms of the practice direction so and so. Who will take?
My lord. My lord.
POCSO?
Yes, POCSO, my lord.
Who will take upon respondent number 2 victim?
Respondent number 2 not given. Amicus query has to take this.
And we just observe a
Yes.
service report is to be obtained thereafter from the officer in charge. Pangsari Police Station. Post of. Yes.
But,
To
there-
represent the
yes,
case of the accused appellant.
one matter, Surajit Das can see.
Mr. Surajit Das.
Again, my
Learned
lord.
counsel from the panel of
Yes.
Amicus Curie.
Hello there, Arunab Fukan. And
Amicus. So single bench was single bench. His name is there.
Arunab Fukan there and in single bench,
Okay,
Surajit
Surajit
Das
Das.
also there.
And is appointed. Full stop.
Puja
Or registry to reflect the name of Mr. Surajit Das. Learned. Amicus Curie in the for the appointed for the accused appellant in the cause list. Full stop.
$24 also my lord, same jail appeal. ma'am.
Jail appeal.
No, sir, 24 and also 25 also.
Jail appeal. Judgment and order was judgment dated 11/4/2025 and an order on sentence dated 16/8/2025. And 304 Part 1 IPC Court Session Judge Sivagar, Session Case number 143 in bracket SS of 2020. If you head to pipeline, 3042. Rigorous imprisonment 10 years, fine 5,000, default 6 months. Yate practice direction part 2 nalage. If responsible 2 nalage. Yes. Whom should be appointed?
My lord, here Arunab Fukan is there.
Arunab Fukan. Next. Mr. B. Halda, learned legal aid counsel for the accused appellant, and Mr. MP Goswami, learned additional public prosecutor for the respondent state. Respondent number 1 state. Criminal appeal 415. Judgment and order dated 20/05/2025. Sessions Judge Udalguri, Assam. Case 9 Aru. Page 20. 448 and 376.
Yes, Lordship. 448 1 year and 376 10 years.
Admit these case records. Notice returnable 4 weeks. MP Goswami 1, steps upon respondent number 2. I think 376 not by speed post. Speed post, it's your. Yes, sir, got name of Mr. B. Haldar, Land Legal
should
Council
go
is to be reflected in the cause list.
Go through the registry.
Steps by speed post. You get reimbursed, na?
Reimbursement. There is an IA also. IA 102
Let it
reimbursed.
come. Let it come. PCR be received.
In all these cases, can we ask for a copy, my lord?
Huh?
Member.
Paper
book, my lord.
General practice, Lordship,
Registry.
we have
So
to.
far,
Yeah.
appeal and IA,
Yes.
have you received?
No, my.
Already furnished. Before filing without submitting the document,
Next,
it has
next.
no number.
Look.
Family court.
May I please kindly matter may be passed over for today, your lordship.
The matter relates to my lord.
Family court.
Yes.
Let it appropriate bench, maybe. Let it put to the rest. Mr. Anjay Kwari, learned counsel for the petitioner. And Miss
HG Daisy.
SG
Daisy.
Daisy for the respondent are present. It will be given. Like counsel for the parties, notification, appropriate bench. Let it come back.
But it is a criminal revision petition against maintenance order, right?
That is why there is confusion.
God bless your lordship.
Mr. Rajiuddin, are they ready or otherwise it will take some time, right? Or some other date. Are you ready?
Yes.
So there are other cases also.
Keep it as parted next week, can you do?
No, we'll keep parted. I have been suddenly informed that my bench has been changed.
Unless my lordship has heard the matter at length.
But better you, when do you want? No, but I don't have the roster now.
If it is
Some other day.
parted, then it will come out.
No, I'll not give. There are other parted matters more serious.
Then quick.
AIuddin petitioner is Sage Bora, respondent number 1, and ASG Borua, for respondent number 2. Lays the case on. When do you want? You have
And
urgency?
is saying that next week your lordship has 7 minutes makes a matter. On 10th?
No, because I don't have that roster now.
Lordship.
On
it is
10th?
only-
Like just parted.
No, I'll not keep parted.
After my 9.
Then before that, Miss Bora is ready already.
Lordship, I'm ready, but from the next week, I won't be available on medical ground.
Where is Mr. Goswami? Hand over all the materials to him.
Lordship.
6th of February. He is expressing urgency. Otherwise, also state has asked urgency.
Lordship.
If there is a mandate
Yes, Lord.
to conclude trial
Law has
under
to be
POXO.
settled.
Yes.
So he has also urgency. You have urgency.
I have was now 7 OP.
Still he is seeking quashing.
Yes.
So he has a right. So that we cannot deny him. It has to be hard on merits only.
I have questioned the trial, therefore.
Right.
I know.
If your lordship held that trial is illegal.
It is still open for him. 6th. Now MP Goswami will take over.
Lordship.
6 again on Friday, my lord. Can it be any hearing day?
No, since I don't have the roster, I should not fix for others. That's why I fixed it on Friday. Consciously. Had I been sitting, I would have fixed it on Tuesday or Thursday.
Of like
But you have an interesting point.
Please, Lordship.
Huh.
Lordship, the parties has come to an amicable settlement, so I have the instruction to withdraw this. Already.
Okay.
I did affidavit also.
Okay. Now you say, Mr.
M. Hendrik.
Heard Mr. M. Hendrik, learned counsel for the petitioner, and Mr. L. Gogoi. Who else are there?
Respondent number 2.
2. Mr. MP Goswami, learned additional public prosecutor for the respondent number 1 state. And Mr. L. Gogoi, learned counsel for the respondent number 2. So stop. Mr. Hendrik, learned counsel for the petitioner, has submitted that since a compromise has been arrived at between the parties, and to that effect, an affidavit has already been filed on 19/1/2026, which is available in the case record, the petitioner wants to withdraw his transfer petition. First of, Mr. Gogoi, L. Gogoi, Mr. Gogoi, learning counsel for the respondent number 2, has supported the submission of Mr. Hendrik as regards the compromise, right? First of, in view of the above submissions made by the learned counsel for the parties, this criminal petition stands dismissed on withdrawal. The interim order passed earlier stands recalled.
Obliged.
Objection. My lord,
Orders ketia pa amod.
notice was issued on 28/1/25.
Orders ko pa amod. That's it. Admission proof hoi gol. Okay.
My lord, notice was issued on 28/1/25. And today is a returnable date. Perhaps my learned friend may file objection or may be fixed for hearing.
Lordship, my senior is coming. He will do a hearing, Lord.
Tunisia say, it is same vicarious liability.
Lordship.
Vicarious liability. Enact.
Enact.
Whether there is vicarious liability or not.
We are praying for
I have understood.
Proceedings on the ground that the petitioner was not a signatory on the.
Right, I have understood.
Yes.
So there is no vicarious liability.
No
That's your case.
Yes, no liability.
Yes, what is your, ready or not ready?
This, Lordship, my senior is just coming, Lordship.
Who is your senior?
Vicky Medhi, Lordship.
Today is fixed for admission. Lordship will fix it for hearing.
If I find it is a good ground to pass, we will pass.
Yes. I'll be highly obliged.
Yes.
Lordship.
Where is the check? Part of the case record.
Yeah.
Check is the part of the case record.
Check it, yes, my lord.
Huh?
It was not
Page,
annexed.
Which page?
No, it was not annexed, my lord.
Check
Huh?
is not there.
That I should have a look at the check. I should have a look at the check.
Then a trial court record is to be called for.
Only the look is sufficient.
Check was issued to them. They should have it.
Your Honor, they have filed the petition, they should have annexed it, my lord.
No, we have already issued the check.
No, copy is there, no?
We have not retained.
He is not the, no, you don't have the copy of the, you have got the copy of the complaint.
Yes, my
Yes.
lord.
But not the annexer perhaps.
Along with the evidence, my lord, we have provided them.
Then it should.
Then let the scan copies be called for them.
Yes, trial court record may be called.
My lord,
If both are reluctant to hurt Mr. P. Bhomik, learned counsel for the petition. and Mr. D.K. Medil, and Mr. D.K. Medil, learned counsel, who has entered appearance on behalf of the respondent, sole respondent. So, for adjudication of the issues raised, a look at the records of case records of CR case number 5065/2019 would be necessary to stop. Let the scanned copies of the case record of so-and-so be called for. Release the case on so-and-so. The interim order passed earlier shall continue till the.
My lord, there are two analogous matters, my lord, between the same parties. That is criminal petition 69 and 74. My lord, those may also be tagged along.
Okay, release the case on so-and-so along with so-and-so. You give the list. You give the list.
Obliged.
Ini apa? Saya apa juga? Ada orang बहुत बेसी. No, not 23. I got. Oh, no, was March, no. March first week ago. Already bored of this.
Hey, please, Your Lordship, this matter can be taken up some other day, Lord.
Okay, on the request from Mr. B. Chaudhary, learned counsel for the applicant. List the case after a week on a date to be by the office. Mr. MP Goswami, present.
Valid.
He's 74. So
Maybe His Lordship.
bring what is the stage? Respond number
this-
2 served.
My copy served and my respond number 2. She is appearing as legal aid counsel, ma'am.
Okay, Mr. E.
Yes.
Chaudhary.
Yes, ma'am. I may be taking up some other day for the.
Hey, some other day.
Some other day. Yes. LCR.
Yes.
The proxometer LCR has to be inspected.
Yes, madam. There is a pair.
I am ready for to.
Miss Anne
Yes,
Hassan, learned
yes.
legal aid counsel for the appellant, Miss MP Goswami, additional public prosecutor.
Respond number 2 is
Respondent one,
appeared.
State of Assam, and Miss U. Sharma. You have entered by Karanama. Huh? Okay, Miss U.
Yes, ma'am. Yes.
Miss U. Sharma, learned counsel on behalf of Mr. U. Chaudhary.
You sorry, she is for the.
Learned legal aid counsel for the respondent number 2. So stop. On the prayer of the respondents, learned counsel for the respondents, let the case be listed on
date. Those.
when? 16/2. Yes. Yes.
Lordship, I'm seeking adjournment of this matter, Lordship. Mr. D.
Sorry for keeping you waiting because they are in a queue. Other cases were in. No. In this case, I thought that by the time it will be over. Otherwise, I don't fix cases at 2.
Madam, yes, madam. Madam, he told me so. I was in another court, my lord.
So it will be taken up.
Mr. D. Gogoi is not well today, Lordship. Matter may be taken Monday, Lordship.
Not well.
Yes, Lordship.
If not well, then
Matter may be taken Monday, Lordship.
Dixit Gogoi. Dixit Gogoi.
Dixit Gogoi, yes, Lord.
If not well is the ground, then
He's only more than 400 days. Defend them. There is.
you put it on.
Can it be by Monday?
Monday.
Not Monday. Wednesday. Wednesday. Because problem will be in listing.
Yes.
H.S. Chaudhary, Learned Senior Counsel, estate by Mr.
Eti
Eti Sarkar, Learned Counsel for the applicant appellant, and Mr. M.P. Goswami, Learned Independent Public Prosecutor for the state are present. A prayer is made on by Mr.
K. Kashyap.
K. Kashyap on behalf of Mr. D. Gogoi, Learned Counsel for the respondent number 2. On the ground that Mr. Gogoi is indisposed. He is not well.
Not well.
Post op, and has thus sought for listing of the case on a date in the next week. Post op as agreed to and sought for by the Learned Counsel for the parties, list the case on Wednesday. Sorry for this inconvenience.
Only thing, madam, on Wednesday, if you also allow.
No, unfortunately, I am not in the roster.
Right, let us see, madam.
So I cannot direct the other roster just to take up your case.
Such things happen, madam.
As Islam, Learned Counsel for the petition is present.
Service situated.
This is okay. Private.
Private.
Peruse the office note dated 28/1/2026. Await for the service report in respect of respondent, sole respondent. List the case on. He will give. You have appeared.
I'm for the respondent, Your Honor.
34.
Your Lordship,
Yes.
here may I please to Your Lordship, I am Advocate Malaya
Ah.
Ghosh, Karimganj. I am petitioner in
Yes,
personal.
madam. Do you have any objection to condone the delay of 11
Yes,
days?
Your Lordship, as it is more like 80 days approximately.
80 days?
Yeah.
Okay, file objection then. Madam, the respondent counsel has entered appearance and is submitting that there is 80 days of delay.
Opposition আছে.
Let him file objection.
My Lord, actually there is just 11 days.
Your Lordship, objection has been filed.
It is not on record.
Yes, yes, file.
Right. Heard Miss M. Ghosh, petitioner in person through virtual mode. Full stop. Somebody go para. Next para. Miss
D dash.
D. Das. Learned Counsel has submitted that she has entered appearance on behalf of the respondent. First stop. MS Das, next. MS Das has further submitted that an objection to the instant application has already been filed as according to the respondent, there was 80 days of delay, right?
Yes, approx 80 days. Your Lordship.
Approximately 80 days of delay
11 days.
in preferring the
Lordship, it's 11
accompanying criminal revision petition. Full stop. Para. The objection, stated to have been filed on behalf of the respondent, is not on record. Full stop. Para. List the case on so and so in the admission column with the objection, stated to have been filed on behalf of the respondent, on record.
Your Lordship, please
2nd
fix-
March.
Please fix the date.
2nd March.
My obliged. Thank you.
Item 35.
হয়ে গেল।
Yes.
May I please the lordship, last time, my lord, this criminal appeal wrongly registered as a criminal appeal registered, my lord. It must be registered as a criminal revision, my lord. And last time I have filed another IA criminal for correction amendment of the main criminal appeal with the IA for condonation claim.
And it is registered at IA criminal 46/2026.
What has happened? 46. It is not with the record. File on. Yes, power. Let's make. Koira bari. Koira. Convict. Convict. Vishwajit Sen. Vishwajit Sen. Vishwajit Sen. Affirm. Under what provision?
Lord, under Bharatiya Nagarik Suraksha Samhita.
Huh?
Under
Which provision?
under section 442.
442.
528 of Bharatiya.
442. Let us see. 442. Subsection 5 is other way.
Under section 442 High Court's power of revision, my.
Right, there is a specific power.
And under
Madam.
CRPC it is 401, my.
Right, madam. I understand. Because revision is not a matter of right. Firstly, it is not a matter of right, like appeal.
Let him.
Now read subsection 5. Subsection 5.
Yes, I'm going through the subsection 5, where under this Samhita, an appeal lies, but an application for revision has been made to the High Court by any person, and the High Court is satisfied that such application was made under the erroneous belief that no appeal lies thereto, and that is necessary in the interest of justice. So to do. The High Court may treat the application for revision as a petition of appeal and deal with the same according.
Not the other way around.
Reverse it.
Not the reverse. Suppose you preferred a revision and High Court finds that their appeal lies and you have wrongly preferred a revision.
Yes.
High Court can convert into appeal, right? But you have preferred an appeal and High Court finds that appeal does not lie. In fact, a revision is permissible. High Court, by this power, cannot convert into a revision.
Yes.
You will get all the benefits of Section 12 of the Limitation Act. So I thought that you would understand and thereafter make appropriate prayer. I think that is the understanding. I thought that you would do the needful, you would withdraw this petition because of this confusion, and seeking the benefit, you take leave to file the appeal revision afresh. I think that was the idea.
Yes.
And a power which is not vested in me, I will not exercise. show me. It is specific, subsection 5. Suppose you have wrongly filed as a revision, but appeal lies, then High Court can convert it to appeal. Appeal. But not the other way around. Have you understood? What you have understood? What?
Revision may be converted to appeal.
If you have wrongly filed a revision petition instead of appeal. But if you have wrongly filed an appeal instead of a revision petition, it cannot be converted by this High Court. This is my understanding of the law. What do you say?
Your Lordship, I can either, there is no alternative, either I withdraw the appeal.
Section 12 of the Limitation Act that wrongly pursued somewhere, then that benefit can always be availed. And since it is a convicted person, definitely no court will deny your prayer.
Yes.
But you can try your luck. Not before me, at least. I'm not going to misuse the provision of law. Otherwise, there will be a nullity. On the prayer of Miss B.R. Sultana Lanit, Legated Counsel, this is the case after MP Goswami.
Yes.
Lanit Additional Public Prosecutor for the state is well. Some, you may, I'll not say much. Not by me.
Item
Can it be? Can it be?
So far, madam, this is.
If it is very specific provision, something cannot be read into it.
39.
Yes, Mr. Sarkar.
Yep, sir.
80 Sarkar and Council for the petitioner MP Goswami. 1 present. Here is the office note. Dated 28/1/2026. Full stop. Issue a reminder for the scan copy is of the case record, right? Scan copies of the case. Scan copies of the TCR. Full stop. Yes. First steps.
This personal lordship, I may be allowed to serve can he communicate the response?
Why you have made a police?
He was the informant.
Mr.
Yes.
Mr. Goswami has submitted that since the respondent number 2 has been employed in the capacity of the informant in CID case number 28/2018, he can represent him. Also,
No, so I will take the instruction thereafter because it is by name.
he will take instruction.
Yes.
From the respondent number 2. As regards his representation.
Yes.
Post of para. List the case on so and so. Let him take the instruction.
Yes.
41.
Waziruddin. Petition seeking passing of so and so, pending before so and so, spec step. Respondent number
28/1, my lord. This is
I alone.
Sheikh Mat.
T Sheikh for the petitioner, MP Goswami 1. Peruse the office note dated 28/1/2026. Await for the service report in respect of the respondent number 2 and the TCR. This is the case on.
Item 42.
May I please, your lordship, the delay content, 1 day delay was.
1 day revision petition, judgment in order passed by
It was filed in 8
sessions.
December is Sunday, my.
Yes.
Third, Mr.
CS Rai.
C.S. Rai, learned counsel for the applicant, and Mr. M.P. Goswami, learned additional public prosecutor for the opposite party. Number 1, full stop. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 1 day in preferring the accompanying criminal revision petition against a judgment dated 27/8/2025, passed by the Court of Learned Sessions Judge Bojali Pachala, Appellate Court, in Criminal Appeal number 10 of 2023. Full stop. By the judgment and order dated 27/8/2025, the Appellate Court has dismissed the criminal appeal preferred by the revision, the applicant herein against a judgment and order dated 4/8/2023 of conviction and sentence passed by the Court of Learned Chief Judicial Magistrate Bojali in NI case number 52 of 2021. Trial court. The trial court had convicted the applicant for the offense under Section 138 Negotiable Instrument Act 1881 as amended, and had sentenced him to undergo rigorous imprisonment for 1 month and to pay a compensation of rupees 7 lakh to the complainant, in default of payment of fine, to undergo simple imprisonment for 2 months. Full stop. I have gone through the statements and affirmations made in the instant application, more particularly, paragraph 4 thereof. Full stop. As the period of delay is only 1 day, only 1 day, and the accused applicant has been sentenced to undergo rigorous imprisonment of 1 year and to pay a fine of rupees 7 lakh with default stipulation, interest of justice, in the considered view of this court, would be better subserved if the accompanying revision petition is heard on merits by condoning the delay of only 1 day. Accordingly, is without a registry to raise it. So, as the period of delay is only 1 day, this court is of the view that what's Sunday?
Sunday, 7th is Sunday, yes, I learned 8/12. 7/12 for Sunday.
Okay,
I learned 8.
1 day. First of, this court finds that then there was no delay. Huh?
No, after calculate for acquiring certificate.
As the period of delay is only 1 day, this court further view that there is no necessity to issue notice to put the opposite party, number 2, there's complaint on notice, as it would be hard at a time when the accompanying revision petition, criminal revision petition, comma, if admitted, comma, on merits and it is hard. Or when it would be hard on merit. Also, the registry to register company. The same. Expeditious.
Punishment is 1 month.
1 month and 7 lakh.
Doesn't not upload affect only copy.
Okay, okay. The criminal petition appeal was partially allowed by modifying the sentence to the extent of compensation is 7 lakh only and removing the sentence of rigorous imprisonment of 1 month. Right?
1 month.
That is removed.
Yes.
43. You ready for 20%?
Yes, yes. No, we had deposited in.
20% you have deposited?
Before appeal.
Oh, it is already there.
Published.
UN Chetri. Mr. Paul Oscar Learned Counsel for the petitioner. Who put this application under Section 5 of the Limitation Act 1963 is prepared seeking condemnation of delay of 282 days in filing the accompanying criminal revision petition. Private party, right?
Private.
Issue notice, returnable for weeks. Steps, speed post, 2 working days. Hola?
Obliged.